Tomorrow. Tomorrow I can give first. Tomorrow only. Tomorrow I can. Two 2:30. 2:30. Huh? Tomorrow it will be. It's required. Certain? What clerk? Just I will verify it. You give them, I will verify. Tomorrow. Nothing, nothing will happen. Tomorrow you can. Yes, tomorrow too. Yes, sir. Tomorrow. Tomorrow, tomorrow let us. At 37 at the request made by the Lana Council appearing for a petitioner this next Tuesday. The request made by the petitioner list Monday.
May I request?
Yes, sir.
Serial number 27. Serial number 27 have it tomorrow.
Yes, sir. Serial number
27. Only I ask requesting you to grant me one day accommodation tomorrow.
Raghavendra 25 at the request made by the petitioner list day after tomorrow.
Whichever.
About 48 to 48.
Number 46, my lord.
42, sir.
Respond.
The request made by the petition list next week.
My lord,
Yes, sir.
may I request the date
Number
in
46.
serial number 46? The request for adjournment that was made. May I request for
46, which you are for?
I'm for the petitioner, please.
The request made by the petition list next week.
My lord, may I request for a date to be fixed?
Let us will. Today is a good day, but you are seeking.
My lord,
No,
I am
sir.
not. My lord, I am not seeking the
Who is
adjournment.
seeking
My lord. The request came from the respondent number 3. My lord.
The respond
seeking
number 3. At the request made by the respond number 3, a list next week date could you? 21st. Yes.
I'm ever so grateful. My lord.
Serial number? Serial number? 44 at the request made by the Lena Council appearing for the respond number 4, this next week date. Interim order granted earlier, next date. Only thing is the judgment insofar as that's we only reverse it. That's why it is. But just 1 minute. Just let us see 57877. Recommend in favor of this. Now you issued the endorsement. 22. Just I will say. Third, the Lana Council appearing for the parties. Leonard AGA. Full stop. This petition was disposed of on dash. However, 30th 10 so 2023. However, due to the mistake crept insofar as the filing of the endorsement, the matter was taken up today. In this writ petition, petitioner is seeking direction to respondent to issue Sagoli chit in respect of the land in question. Then a DG files memo stating that the respondents have taken decision by issuing endorsement dated 8/11/2022, accepting the said endorsement, the writ petition is disposed of, reserving rejected, reserving liberty to the petitioner to challenge the same if so advised. What about the next one? Except that everything is correct. So this one, endorsement dated 13/10/2020, AG. Remaining things. 17. After 5 years. Panchavarshika Yojana. Panchavarshika Yojana. Third. Then take decision by accepting the annexure B. Endorsement is given. So one thing, give one more representation saying because insofar as this land is concerned, endorsement is issued rejecting this actually. Where is the endorsement? Sir? ಸದರಿಗೆ ಮಂಜೂರು ಮಾಡುವ ನಕ್ಷತ್ರ ಹೆಸರು ಯಾವುದೇ ಖಾಲಿ ಜಾಗ ಇರುವುದಿಲ್ಲ. Yes. 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 It is submitted by the Leonard AG that the instructions will be taken in so far as the alternative, the property be given to the petitioner in lieu of the endorsement dated 27/3/2019 issued by the respondent at office. This chapter 2 weeks. EDLR is not working. Huh? $230. Get it signed and produce. Otherwise, let will present. He's working well. He's in India only. Then no problem. How many times you have to tell? It's a third time. It's not first time, second time. Okay. Third time, last time it was. Get it signed and give it to them by 2:30. Pass over. If he is so busy that he will court shifted to the revenue. We all of us will go there. If he's so busy with doing all this work. Not correct. It's a third time I'm giving. Get it signed and produce by 2:30. Who are you? There are necessary part, maybe hello. Just tell me, you, what your challenge in this petition? ಕಾಯ್ದೆ ಯಾವುದೇ ರೀತಿ ಚಟುವಟಿಕೆ who are you actually? Hello, who are you? You are an allottee of the? No, you are an allottee. Hello, you are an allottee. Allottee of which? Yes. So order in the said writ petition has been passed relating to the very same land. We will hear him take. No. Anyway, an order has been passed by this court in so for the very same survey.
I'm thinking, but there is already a recommendation. Anything
No, we will allow the application. We will hear him take decision. Thing will have. I would heard the Lana Council appealing for the parties on IA 1/21 filed by the impleading applicants. She can't be Lana Council appealing for the impleading applicant submitted that the impleading applicants herein have preferred two writ petitions before this court, which has been produced at annexure K and L to the writ petition, comma, which relates to the property in question, and he shall be heard in the matter. In that way of the matter, in that way of the matter, I'm of the view that the impleading applicants claims to be the allottees of the land in question, and in that way of the matter, the impleading applicants or the necessary parties, according to IA 1/21 filed by the petitioners, filed by the impleading applicants is allowed. Impleading applicant shall be arraigned as respondent number 7 and 8, 7 and 8, 7 and 8 respectively. Council appealing for the petitions permitted to amend the cast title and to file the amended cast title. Learned AGA seeks 2 weeks time to file statement of objections. Let us read. Interim order granted earlier, extended till next set of hearing. Full cast title you furnished. Office objections were there. Yes. What is this matter actually? Huh? Huh? What is this petitions? What are? Huh. The first petition, annexure T is challenged. What is annexure T, sir? Yes, what is wrong with this? Huh? Yes, sir. Let it be. What is the wrong in the order? It's correct. But it is a government land. Huh? When it was granted? Where is the order? Where, annexure? Granted land. Where is the Sagavalichi? Where is the Sagavalichi? Well, one. Then what is your legal right now? No. Once you purchase the property, and your sale deed has been you can agitate your right before the competent authority. You have approached the civil court also. The suit for declaration is filed. Then agitate. That was to say that respondents have produced only the revenue documents such as RTC extras, but the revenue title to receive. Anyway, you did. No, need not be. No, you have heard actually. Nothing much you can hear. Nothing much you can submit also. That's why the suit is filed seeking declaration. Matter relating to the PTCL is pending before the deputy commissioner. What else could be done? You are only a purchaser. Yes. Nothing else. I think you establish your right first. Better establish your right. Third. No, that cannot be. That I will establish your right before the civil court. OS number 1199 of 06. 1199 of 216 is money up. It is filed. It is dismissed. Just one. Just no. Lawful possession and enjoyment, absolute owner in possession of his own. Anyway, the order suit is dismissed. What is that suit number? No. Anyway, it is not disputed. You can declare it's heard the. Yes. Let will establish his right. It is open for you to pursue your remedy insofar as before the PTCL. So far as this matter is concerned, Mohan Kumar. Just a minute. No, nothing is. No, it is only insofar as the Mohan Kumar is concerned. That is who you are appear. Yes, who appear for the Mohan Kumar actually? Mohan Kumar. Yes. Anyway, all the parties are established their right. So, in this writ petition, what about the next one? 6.1. 6.1. Writ petition 6.1. What is this? Ah. Who you secured this property? How did you get this property? How did you get this property? From whom? Fifth respondent. Let us take first. Let us take up first. In this writ petition, please sit down. Please. On a criminal matters, in this writ petition, please sit down. Petitioners are challenging the order dated 25/3/2021 between bracket annexure T in T passed by the second respondent, relegating the parties to establish their right insofar as the property in question. The relevant facts for adjudication of this petition are that the petitioners that the third respondent hearing has lodged a complaint to the revenue authorities, resulting in the initiation of proceedings under section 136 class 3 of Karnataka Land Revenue Act 1964 in respect of the land bearing survey number 156/50 measuring 2 acres at Kulumangala village, Jigani Obli, Anekal Taluk. It is the case of the petitioner that the The third respondent has contended that the land in question is a Goma land and same has been sold to different persons. And finally, the fifth respondent has appeared in the said land under the gift deed from her mother. And fifth respondent herein has created certain sale deeds. And in this regard, an inquiry, a proceedings was initiated before the revenue authorities, and the second respondent herein has issued notice to the petitioners as well as the respondent number 5 here. It is the case of the petitioners that the subject land is belong to one Gurappa alias Muniga, son of Timmaya, who was grantee of the said land under Darkas grant rules as per Annexure A to the writ petition. It is also stated that the relevant revenue record stands in the name of the original grantee, Gurappa alias Muniga. In this regard, it is the case of the petitioners that the petitioners are the purchasers of the land in question as per the sale deed dated. What is your sale deed, sir? Your sale deed. Annexure. There are 3 sale deeds, sir. What is your sale deed? It's also the case of the petitions that the petitioners hearing have purchased the land in question as per the sale deed dated 30th 3 2019 within bracket annexure K to the writ petition. Hence, it is contended in the writ petition that the impugned order passed by the second respondent is contrary to law. Accordingly, the present writ petition is filed. I heard the Learned Council appearing for the party so and so. It is the contention of the Learned Council appearing for the petitioner that the petitioners herein have purchased the said land as per the sale deed produced at annexure K to the writ petition. Accordingly, contended that the finding recorded by the second respondent herein to relegate the parties to the civil court to establish their right is not correct. Per contra, the impleading the Learned Council Sri Badrinath appearing for the respondent number 4 contended that the land in question comes within the purview of the is a granted land, and in this regard, the Assistant Commissioner, which is that order nullifying the you have placed the order. That is SCSTA 26. Contended that the land is Sri R. Badrinath contended that land in question is originally belonging to the ancestors of the respondent number 4, and in this regard, a proceedings have been initiated under section 5 of the Karnataka Scheduled Caste and Scheduled Tribes within bracket prohibition of transfer of certain lands, close the bracket Act 1978 before Assistant Commissioner Bangalore South Division and the Assistant Commissioner by order dated 1st February 2023, ordered that the granted land be restored to the legal heirs of the original grantee. And in this regard, the proceedings are initiated before the Deputy Commissioner by way of appeal, and same is pending consideration. In that way of the matter, he submitted that, the writ petition does not survive a consideration. Then the council appearing for Leonard AGA, sought to justify the impugned order passed by the respondent number 2 on the ground that the disputed questions of facts are involved in this. In the light of the submission made by the Lana Council appearing for the parties, on careful examination of the aforementioned submissions made by the Lana Council appearing for the parties would indicate that the disputed questions of facts are involved in this petition, and therefore I'm of view that the same cannot be adjudicated under Article 226 of the Constitution of India. Perusal of the writ papers would also indicate that who is Muniappa actually? Yeah, would indicate the original the it is it's also forthcoming from the writ petition that a suit in OS number 1199/2006 was preferred before the senior civil judge and James State Anekal, Bangalore Urban District, by one Muniappa, claims to be the original grantee, and the said suit came to be dismissed, and against the said judgment and decree, the appeal is pending consideration before the competent. It is also submitted by the Lana Council appearing for the parties that the petitions herein have also preferred the suit before a competent court seeking relief of declaration one has filed suit in OS number 194/2020 before a competent court seeking declaration in respect of the subject matter. That way of the matter, unless the rights of the parties are crystallized before the civil court, no further interference be made in this writ petition. It's also, that way of the matter, I'm of view that no interference is called for in this writ petition. All the parties, the rights of the parties are kept open relating to establish their right in respect of the subject land before the civil court, as well as before the competent court, before the before the deputy commissioner in the proceedings filed under the provisions of the KPTCL Act 1970. Accordingly, the petition is dismissed. Yes. What about next? 6.1. Yes, sir. What your challenge? Annexure A, impeding applications are accepted. Impeding applications are accepted. What is this matter, sir? Your challenge annexure A. On what ground that you challenge this order? Who are you before the deputy commissioner? Fifth? You are a fifth respondent to commend it. Yes. Just a, let us listen. What you will say, let us listen. Yes. Yes, sir. How you have purchased? This is connected with earlier, same. Then you have to establish that. You are a petitioner? No, 6 point, no, I'm setting up 6.1. 6.2 I will come later. Yes. Okay. So what will happen in 6.1 and 6.2 will go together. Yes. What about 6.3? 3 also. Yes. Let us will see. So 6.2 that you claims to be the grantee. 6.2 put in. 6.2. So what will happen? 6.2 will be applicable to 6.1 and 2. Yes. Just 1 minute. Connection A is challenged. You see that is originally granted to one Joga and thereafter is just respondent has become Khatedar. Where is the grant order? Where is the grant order? Then once you produce a grant order, then only that you have to produce. That is a contention. Annexure 88. Just Tahsildar. PTCL ಪುನಃ ಮೂಲ ಸಂಶಯಾಸ್ಪದ ಇರುವುದಿಲ್ಲ ಆದ್ರಿಂದ but you have to produce a grant. You have to produce actually. Yes. Yes, sir. That's what. Connection A. But now you have to produce the grant order. You cannot rely upon annexure F and F1. ಯಾವುದೇ ಲಭ್ಯವಿರುವುದಿಲ್ಲ. There is nothing wrong in these petitions. The Deputy Commissioner has rightly pointed out that since you are not produced, it cannot be. That's what that you have to. Yes. Yes, that's what. No. No, since 21 you are not produced before the Assistant Commissioner. Not. Yes, maybe. The finding recorded. Third. No. Sir, that was a finding recorded. You don't have copy of the same. No. Yes. Maybe dropped, but now you have to produce. No. That you cannot produce. That was no. You cannot get it by overnight. Since what not you have to secure for more than 20 years, you cannot get it. by 24 hours. Nothing else. Yes. Yes. Ah. Yes. 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 Paragraph 12. Yes. Cannot be stated. State itself could be an appropriate party when order is placed. After affirming the correctness, it will be maintained by the state. Consequently, private person benefit. Yes. Yes. No, it is not fraud actually, but it's not granted. Fraud is different from granted. That was a fraud. If it is a fraud, it's a different thing. Grant? Only thing is, if the land is granted, that's it. What is this? Yes, sir. Serial number 5. Yes, sir. Where is the grant certificate? Was your case that land was granted to Jogattiga? Yes, sir. It is only the Saguvali Iduvali. I want grant certificate. Saguvali will be made there without grant. Hard list. No. Okay. 6.1, 6.2, and 6.3 together. In these writ petitions, the in these petitions, the common question of are required to be adjudicated in these adjudicated accordingly. At the consent of the Learned Council appearing for the parties, the matter was taken up for final discussion. It is the full stop. It is the case of the petitioner in WP number 1304 of 2021 that the order dated 8 October 2020 passed in RRT proceedings by the second respondent is contrary to law. It is the case of the petitioner in the said writ petition that the land in question was originally granted in favor of one Jogattiga, and after his death, the petition hearing has become the Katedar of the said land. Hence, the petitioner has questioned the order dated 8 October 2020, within bracket annexure A, passed by the respondent. The petitioners in WP number 1215 of 2021 and WP number 1924 of 2021 are claims to be the purchasers of the land in question from the petitioner in WP number 1304 of 2021. Hence, these writ petitions are filed challenging the impugned orders passed by the Special Deputy Commissioner -2 Bangalore South Division, Bangalore District. I heard Sri Badrinath or Sri Vijay Shekhar Gowda, counsel for the petitioner, and so on, so Leonard VG. It is contended by the Leonard Sri Badrinath R that the land originally belonged to one Jogatiga alias Gogattappa, the father of the petition herein, by order dated 1/1/1941, and thereafter the father of the petitioner and the petition, and after his death, the petitioners are in possession of the land in question. Accordingly, the respondent number 2 at the at the later at the later stage of the period cannot cancel the grant made in favor of his father. Accordingly, sought for interference of this. He also sought to rely upon the judgment of this court in WP number 46616 of 2017, disposed of on 9th October 2023, and urged that the respondent authorities ought to have taken action within a reasonable period by exercising the suo motu power against the petition hearing accordingly, and therefore contended that the impugned order is liable to be set aside. Per contra, Mr. Leonard AGA so and so submitted that since this per contrast, Leonard AGA, sought to defend the order passed by the second respondent hearing and submitted that since the petitioner has not produced the relevant certificate to establish that the land has been granted in favor of his father, and the Sakavali chit insofar as the land in question, accordingly he sought for dismissal of the writ petition. In the light of the submission made by the Lana Council appearing for the parties, and on careful examination of the finding recorded by the second respondent would indicate that the property being granted in favor of the father of the petitioner itself is disputed by the revenue authorities. It is also clarified by the second respondent that the respondent has not produced the grant order under which the land had been granted in favor of the father of the petitioner. So in that way of the matter, taking into consideration the factual aspects that the petitioners have failed to establish their legal right insofar as the land in question, I'm of the view that there is no infirmity in the order passed by the second respondent hearing. However, insofar as the the submission made by the Lana Council appearing for the petitioner, insofar as taking action at the belated stage by the revenue authorities, I'm of the view that, as the finding recorded by the revenue authorities that no grant has been made in favor of the father of the petitioner hearing, and therefore the petitioners herein have to establish their right in so far as the property in question, and in this regard they have failed to do so, and therefore, I'm of the view that the observation made by this court in WP number 46616 of 2017 is not made applicable to the facts in the present case. And in that regard to matter, I do not find any merit in the petition. Accordingly, writ petition number 1304 of 2021 is dismissed. Consequently, as the petitions in WP number 1215 of 21 and WP number 1924 of 21 are the purchasers of the land from the petitioner in WP number 1304 of 2021, and which came to be dismissed as devoid of merits. Consequently, the remaining two writ petitions filed by the subsequent purchasers have no authority under law. Accordingly, writ petitions are dismissed. Yes. Yes, sir. I've also noticed the finding recorded by the annexure F fella. Annexure F. Which is that annexure? Annexure? That is annexure F. Eighteen 98 80. 88, sir. '88 is RTC. One? Oh, that's one. 88 is RTC. F1. 98. 98. I've also ಮೇಲ್ಗಡೆ 98. I've also noticed the order dated, which when was it is? 14/10/2011, passed by the respondent, passed by the Special Deputy Commissioner, Bangalore East Taluk, Bangalore, in RRT within bracket 2//339/2008-2009, wherein in the said proceedings, comma, the Deputy Commissioner has taken decision to take Assistant Commissioner, Vishesha Jilladhikari. The Special Deputy Commissioner had taken a decision that there is no dispute with regard to the grant made in favor of the father of the petitioner hearing. On careful examination of the said order, produced at annexure F1, it is evident that the Special Deputy Commissioner has not looked into the original records pertaining to the land granted in favor, has not looked into the grant records, and has arrived at a conclusion that the land is said to have been granted in favor of the father of the petition. This said finding cannot be accepted on the ground that the third respondent, the second, the Special Deputy Commissioner, Bangalore, Anekal Taluk, Bangalore, has arrived at a conclusion that there is no dispute. However, the said finding is without looking into the records and the original record pertaining to the grant of land, and therefore the submission made by the Learned Council appearing the petitioner in respect of the annexure F1 cannot be accepted. Yes. Annexure? Yes, F1. Annexure F1. Yes. Yes. Same. F1 cannot be accepted. Hence, the petition is dismissed. Yes, next. Yeah, hello. Hello. It will be there only. Let it be there. Next month. No representation on behalf of the petition. The office objection is not complied with within 1 week from today. The petition shall be dismissed without reference to bench. Who has to consider annexure D? No, your prayer is mandatory direct respondent 2 to 4 consider the application. You can take decision in so far as D is concerned. Sorry, office objections are over. And next. Then an AG accept notice for respondents. The short question heard the Lana Council appearing for the parties. The short question involved in this petition is with regard to the consideration of the application made by the petitioners produced at Annexure D, D1 and D2 respectively, seeking grant of the land, grant of the subject land mentioned in the petition. Without expressing any opinion on the merits of the case, the fourth respondent herein shall consider the aforementioned representations produced at Annexure D series within 3 months from the receipt of this order in accordance with law. Accordingly, writ petition is disposed. Yes. Yes, sir. What is this, ma'am?
My humble request, Your Lordship, I am appear for respondent, Keveta.
What is complaints only? What is on merit? Complaints are over. No. Tomorrow you bring.
My humble request, Your
I will
Lordship.
get it. Otherwise, I will get it Xerox and give it to you.
My humble request, Your Lordship.
Yes, sir.
54, section 54, 18, under order 20, rule
No,
18, my
said it will
Lordship.
be complied with it by day after tomorrow.
Please, Your
Then a council appearing for the petition submitted that the office objection will be complied with within 2 days. Let this matter on Friday today. Friday, it will be taken up. Let it will come.
Please, Your Lordship. Please.
Till number 10. No representation on behalf of the petitioner. If the office objections are not complied within 1 week, petition shall be dismissed without reference to bench. Comply with what is the submission? What are the objections? Just one. As per so and so, there copy of the Akar bond to be furnished. It is then a council appearing for the petitioner submitted that the copy of the Akar bond relating to the land in question is produced in WP number 18515 of 2023. Accordingly, office objection is overruled. What is on merits? To remove the B Kata Sakari to conduct court. You can approach, you can make a representation. You can make a representation. Writ of mandamus could be issued only unless you approach them. Where is that? Yes. Connection K page 134. 134. What the prayer that you sought? To remove the B Kata, B Karab and Sarkar in RTC number so and so. What you have sought in the representation? Podi and Durust. They are different. What you are given a representation, what you are seeking prayer in the writ petition are different. Yeah. If you want the writ of mandamus, first approach them. And maybe true, but you have to approach. Writ of mandamus will be issued. See, mandamus could not be issued unless you approach them. You make an approach, then if in the event if refused, or if it is, they may be done also. They may do. Because annexure K is not relating to the removing of the B Kata. Yes. Yes, yes, that I will. In Deputy so and so ರಲ್ಲಿ ಮಹಾರಾಜ ಮೈಸೂರು ಇವರ ಖಾಸಗಿ ಆಸ್ತಿಗಳು ಬಿ ಖರಾಬಿನಲ್ಲಿರುವುದನ್ನು ಎ ಖರಾಬಿಗೆ ದಾಖಲಿಸಿ ಮಾಡಿದ ವ್ಯವಸ್ಥೆ ಅನುಮತಿ ಕೋರಿ ಪ್ರಕಾರ ವಸ್ತುನಿಷ್ಠ ವರದಿಯೊಂದಿಗೆ ಪ್ರಸ್ತಾವನೆ ಮುಂದಕ್ಕೆ ಕ್ರಮಕ್ಕೆ ಸಂಬಂಧಿಸಿ. That's why you can approach them. Let they will. You can approach. What about the remaining writ petitions? You approach them. Whatever you do, let they will approach you. No, let they will approach you, take decision in the matter. Because unless they approach you out a writ of mandamus. No. In these writ petitions, petitioners are seeking writ of mandamus direct in the respond number 4 to remove B-Karab/Sarkari in RTC in column number produced at annexure J series. Inter alia sought to conduct OD duress with the assistance of the respondent authorities in respect of the land in question. On careful examination of the writ papers would indicate that petitioners have not made any attempt by making an application/representation to the respondent number 4 seeking such a relief in the present writ petition. In that view of the matter, without expressing any opinion on the merits of the case, the petitioners be permitted to approach the respondent number 4 by respondent number 4. Respondents, the directly petitioner to approach the competent authority 3 and 5 for redressal of their grievance in a manner known to law. Such an application is made by the petitioner's hearing. Same shall be considered by the respondent authorities in accordance with law. First, you have to make. It's only after you have to make a representation for that also. Same thing. Next matter. With this observation, all the writ petitions are disposed of. ಮೇಲ್ಗಡೆ ಮೇಡಮ್ writ of mandamus ಮೇಲ್ಗಡೆ writ of mandamus will lie unless the petitioner the approach the competent authority seeking public duty seeking discharge of public duty by the respondent authorities. Next matter. Yes, yes. Friday. At a request made by the learned AGA. List on Friday. Yes. So Monday we will take it up. It's of Monday is Friday. Yes. What is this matter? How can the revenue court say that the partition is not proper? What is the jurisdiction of the revenue court to say partition is not proper? Yes, go to annexure J. Yes, sir. Yes. You go to 63 last paragraph. ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು ವಿವಾದಿತ ಜಮೀನು ತಮ್ಮ ಭಾಗದ ಹಕ್ಕನ್ನು ಕೋರುತ್ತಿದ್ದು ಭಾಗಾಂಶದ ಹಕ್ಕಿನ ಬಗ್ಗೆ ತೀರ್ಮಾನ ತೆಗೆದುಕೊಳ್ಳುವ ಅಧಿಕಾರ ಕಂದಾಯ ನ್ಯಾಯ. ಅಲ್ಲದೆ ವಿವಾದಿತ ಜಮೀನು ಕ್ರಯಕ್ಕೆ ಒಳಪಟ್ಟಿರುವುದು RTC ದಾಖಲೆಗಳಿಂದ. Yes, whether see based on the sale deed, ಕ್ರಯ ಪತ್ರದ ನೈಜತೆ ಮತ್ತು ಸಿಂಧುತ್ವವನ್ನು ಪರಿಶೀಲಿಸುವ ಅಧಿಕಾರ ಕಂದಾಯ ನ್ಯಾಯಾಲಯಗಳಿಗೆ. That's why you has been ತಮ್ಮ ಹಕ್ಕನ್ನು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪರಿಸರ. Correct. But anyway the land is, anyway the registered document is there, unless the document even otherwise unless the document is set aside by the competent civil court, there is no rule insofar as it. Yes. Yes. Anyway, you also filed a OS also. Then that was reached. Then there is no settlement. Then it is no, not need not. There is no in fact. No. In these petitions, yes. Yes, nothing. Establish your right in a manner known to you. That in these petitions, sorry. In this petition, petitioner is assailing the order dated 21/4/2023 within bracket annexure J passed by the respondent number 1 and order dated 22/6/2009 within bracket annexure F passed by the respondent number 2, directing the petitioner to resolve his dispute before the competent court of law, competent civil court. Heard the Lana Council appealing for the parties. Having taken note of the factual aspects on record, there are two mutation register, namely, MR 13/99-2000 and MR 16. One is 13, another one is where it is. Next sheet. On 34 ಅಲ್ಲ, MR 16 of 2000, in respect of the said land, so in respect of the subject land. In this regard, it is also forthcoming from the writ petition that the petitioner has filed OS number 41 of 2001, and as it is submitted by the Lana Council appealing for the petitioner, the said suit is dismissed as withdrawn. Is withdrawn with liberty to the petitioner to file the fresh petition. However, without expressing any opinion on the said suit, in the event if it is filed by the petitioner, as the perusal of the impugned orders would indicate that the petitioner has to establish his right insofar as the land in question relating to the fact that the third party rights have been created insofar as the land in question pursuant to the execution of sale deed made by the parties. In that view of the matter, I do not find any merit in the writ petition. Accordingly, there is no error committed by the respondent but 1 and 2 by dismissing the petitions filed by the petition. Accordingly, writ petition is dismissed. Annexure, that is 146 of 23. ಅದರ ಮೇಲ್ಗಡೆ it is full stop. It is also forthcoming from the writ petition that the OS number 146 of 2023 is pending consideration before the civil judge at Sira, and in the said suit, the parties to the said suit have to establish their right over the scheduled property. Yes. The normal, no, that is once you establish, then 127, 129 is. No, nothing will. That could first establish first. Yes, sir. What your challenge? Writ of mandament directing the respondent to initiate proceedings. Why they have to initiate proceedings? And the order passed by this court in WP is not binding on the petitioner. Why? What is the order passed by this court? To make fresh petition. Nothing. Yeah, maybe true. How can the inquiry shall be initiated against you? Against under section 129(3). Yes. What is the locus standi to direct the authorities to take decision in the matter? Purchase then establish your right. That's all. That's all. That will be listed tomorrow. Let us discuss. When you have purchased as per Annexure E. When you have purchased actually. Naveen Kumar. On 16th March 2004. Annexure G. Establish your right. In this writ petition, petitioner is seeking writ of mandamus against the respondent number 4 to initiate proceedings under section 129 class 3 and 4 read with rule 67 of the Karnataka land revenue rules. The petitioner also sought for relief, stating that the order dated 22/6/2023 passed by this court in WP number 8299 of 2023 is not binding on the petition. Having heard the Lana Council appeal for the parties and taking into account the fact that the petitioner herein has purchased the land in question as per sale deed dated 16th March 2004 within bracket Annexure G and Annexure G and the perusal of the order dated 22nd June 2023 in WP number 8299 of 2023 within bracket Annexure H, wherein this court has directed the petitioner hearing to submit a representation to the respondent number 4 therein to mutate the name of the petitioner therein into revenue records, and therefore the liberty was reserved to the petitioner therein to make an application. Accordingly, I am of the view that the second prayer in the writ petition does not survive for consideration, as there is no finding recorded by this court in this writ petition. However, insofar as the initiation of the proceedings under section 129(3) and 4 of the Karnataka Land Revenue Act is concerned, it is open for the petitioner being a purchaser of the land in question as per Annexure G to the writ petition, and he has to establish right in a manner known to law insofar as the petitioner in the WP number 8299 of 2023. In that way of the matter, the writ of mandamus would not lie in such situation. Accordingly, the writ petition is dismissed. Next. IA 1, 2, 3 may be allowed. Accepting the reasons stated in IA 1 of 23, 2 of 23 and 3 of 23, the petition is permitted to bring the LRs of the deceased R4 on record Full stop. Petition. Yes, sir. Yes, already they have served. They have already served. R4 ಅಂತ ಬರ್ದಿರಿ. First. ಅದು next. First in this. First 3 to bring the LRs of the deceased R4 on record and to file the amended cause title. What about the deceased petitioner? When was even that may be allowed, except in the reasons stated in the affidavit accompanying application, IA 2 of 22, 3 of 22, and 1 of 22, or 1 of 20 is fine, sir. Yes, yes. 2 of 22 and 3 of 22 are allowed. Please stop. Petition is permitted to amend the cause title accordingly. This next week, let us see. List after 2 weeks. Notice on IA. Notice on IA. Huh? Is submitted by the Lana Council appearing for the petition that the order impugned in this review petition is challenged before the Honorable Supreme Court in SLP number 4941 of 22, and the said petition accordingly no further orders are required. Issue notice on IA 1 of 23.
Yes. Note.
Unfiling of non-amendment of. Yes, sir. Anyway, that is IA 1 of 18. That cannot be considered this after 5 years. Only thing is sought for annexure A, challenge annexure A, passed by the KET, taken up B group. And
Your Lordship, I appear for responding number 4. My presence may be noted as in.
yes, sir. Yes, yes. Tell me. IA 1 of 18 for seeking continuation of the interim order cannot be considered at this after 5 years. Accordingly, it is this matter when it will read all matters, 50 matters will be reached. This matter in B group any day of third 16th source. In the meanwhile, petitioner shall amend the petition and file the amended petition according. Yes. Yes. Accordingly, IA 1 of 18 is disposed of. Yes. SCGP to ensure that the records of the proceedings of the land be placed before the court. On 10/10/23, my predecessor has passed this order. What do you- This court has passed long back. No, no. or else it may be taken up in B group. That's all. Nothing. Nothing. No. First, get secure the records. Leonard EGA finally seeks 2 weeks time to secure records and to complete the earlier order passed by this court. Yes. Interim order granted, earlier extended till next period. I think similar matters. Such a request made by the Lena Council appealing for the petitioner. Let's just matter in B group next week. Next week.
Serial number 19, my lord.
No, 20, sir. 20. 2 weeks to 28. Yes. Ready. B group next week. It is submitted by the Leonard EGA that statement of objection is ready and will be filed in due course. There's this matter in B group, 2 weeks for 28. It will be late. It will be, yes. 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 What is this matter? Let us. What is the prayer in this matter? That's why it was remanded. Nothing wrong. Nothing wrong in this. It is a remanded. ನಂಬರ್ ವಿಸ್ತೀರ್ಣವನ್ನು ಮೊದಲಿನಂತೆ ಸರ್ವೆ ನಂಬರ್ ದಾಖಲಿಸಿಕೊಂಡು ಸದರಿ ನಂಬರಿನ ಎಲ್ಲ ಹಕ್ಕುದಾರರಿಗೂ ನಿಯಮಿತ ನೋಟಿಸ್ ಜಾರಿಗೊಳಿಸಿ I cannot fix it. I cannot go. I cannot. They will issue a notice. Better. Yes, sir. Issue notice and take this. Anyway, it is only a matter of remand. Anyway, it is a matter of that the notice will be issued to the person concerned and do this. Not correct. That may be true in so far as service matter and education, not in so far as land matter is concerned. I don't want to say that it should be issued to the Learned Council. That they will do as per law. As per law. Tell you. Because even 54 at 60 page is saying that 54 also. The finding recorded at so and so. ನೋಟಿಸ್ ಕೊಡದೆ ಪ್ರಶ್ನಿತ ಇಸ್ಸಾ ಪೋಡಿಯ ದಾಖಲೆಗಳಿಂದ ಕಂಡು ಬಂದಿರುತ್ತಾರೆ. 54. Please answer. Please. In these writ petitions, please answer. Petitions are assailing order dated 24/3/2022 in revision petition number 110 of 2021-22 within bracket annexure A and passed by the respondent number 2 and order dated 2/9/2020 in appeal number 19/2019-20 passed by the respondent number 3 within bracket annexure A1, said to have cancelled the ISSA/PODI in respect of the subject land in the writ petition. Third, the Learned Council appealing for the parties. Having taken note of the submission made by the Learned Council appealing for the parties and taking into account the finding recorded by the page 60, finding recorded by the ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಭೂ ದಾಖಲೆಗಳ ನಿರ್ದೇಶನ A1 is passed by 29 JDLR 2 is ಭೂ ದಾಖಲೆ ಉಪನಿರ್ದೇಶಕ TDLR. Yes, passed by the Deputy Director for Land Records, produced at Annexure A1, would indicate that the said the notice has not been issued to the sixth respondent herein before effecting the POD in respect of POD and the survey of the land in question by the lands in question by the respondent authorities. Since the said aspect has been considered by the Pradeshika Bhudakal, the Joint Director of Land Records, as per Annexure A, dated 24/3/2022, stating that the notice has not been served not has been issued to the sixth respondent herein, and in that view of the matter, both the authorities have passed an order, remanding the matter to the original authority to conduct survey after issuing notice to all the persons or the parties concerned relating to the subject land. In that view of the matter, I do not find any merit in the writ petition, and as the finding recorded by both the authorities to conduct survey after issuing notice to the parties concerned, in that view of the matter, the original authority is directed to do the same in accordance with law. Till the conclusion of the survey and further proceedings before the revenue records, the revenue entries in respect of the subject land shall be maintained status quo. Yes. And yes, sir. Nature of the parties are directed to maintain status quo insofar as the nature of the land is concerned. When it could be done? 6 months. The entire exercise shall be made by the revenue authorities to conduct survey within 6 months from the receipt of this order. Yes. Yes. Annexure B has to be Annexure B. Yes, yes. The last paragraph. ಸದರಿ ಪ್ರಕರಣದ ವಿಚಾರಣೆಯು ಮಾನ್ಯ ಉಪವಿಭಾಗ ಬಾಕಿ ಇರುವುದರಿಂದ ಗಡಿಬಸ್ತು ತಾತ್ಕಾಲಿಕವಾಗಿ ವಿಲೇವಾರಿ. Since the matter is pending before the Assistant Commission. In respect of the here insofar as the 186/9. This is what you sought to consider your representation. No, what is the land insofar as the to be adjudicated by the Assistant Commissioner? Do one thing you consider. Anyway, let you will consider. No, that cannot be quashed, but only consider Annexure B. Because Annexure H, take for an example. Just a minute. to insofar as the quashing the annexure H is concerned. The first question is, how did you get this copy? Next. मान्य पर दावे पदरी दावे what the net notice will be. Plus, what about the R? Oh, is also served. Yes, sir. Yes. Yes. ಸೇರಿ ಸರ್ಕಾರಿ ತೀರ್ಥಹಳ್ಳಿ ಅಭಿವೃದ್ಧಿ ಮಂಡಳಿ ಹಾಲಿ ತಾಲೂಕು ಪಂಚಾಯತಿ ತೀರ್ಥಹಳ್ಳಿಗೆ ದಾನವಾಗಿ ದಾನ ಪಾತ್ರ ನೋಂದಾಯಿಸುವ ಸಮಯದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 186 you are seeking 186/9 186/9 1 acre 34 gunta. What is the I don't know what is the subject matter in so far as the the gift is concerned? That I am not aware of. ದಾನಪತ್ರ ನೋಂದಾಯಿಸುವ ಸಮಯದಲ್ಲಿ ಸರ್ವೆ ನಮ್ಮ ಯಾವ ಪೋಡಿಗೆ ದಾನಪತ್ರವನ್ನು ಸೌರ ಮಂಡಿಸುವ ಬಗ್ಗೆ ನಮ್ಮ ಇದೆ. That is relating to 186. You are not you have no claim in so far as let the fourth respondent will establish the right over. For fifth. Yes. Only in so far as the 186/9. Third, heard the Leonard President or the Leonard Council appearing for the parties. President, in this writ petition is assailing the letter dated 2/8/2022 issued within bracket annexure H issued addressed by the respondent number 5 to the respondent number the assistant commissioner Shivamogga subdivision Shivamogga within bracket annexure H. Having heard the Leonard Council appearing for parties, on careful examination of the writ papers would indicate that the petitioner seeking consideration of the representation dated 5/4/2023 as per annexure F, the annexure B, as per annexure B, is relating to the survey number 186/9 of Konandur village, Tirthahalli Taluk, to an extent of 1 acre 34 guntas. The fifth respondent has addressed letter dated 2/8/2022 within bracket annexure H to the assistant commissioner Shivamogga subdivision Shivamogga with regard to the survey number 86 of Konandur village to an extent of 2 acres, and therefore, taking into consideration the said aspect, the fourth respondent ought not to have addressed a letter dated 2/8/2022 to the assistant commissioner Shivamogga subdivision to enter the name of the fifth respondent hearing in the revenue records relating to the entire survey number of 186 unless the fifth respondent hearing establishes right over the land bearing survey number 86 of Honandur village in respect of the 2 acres of land as it is contended by the respondent number 5 that the same has been acquired by the respondent number 5 as per the gift deed said to have been executed by the donor in favor of the respondent number 5 is concerned. Accordingly, I am of the view that the letter dated 2/8/2022 addressed by the fifth respondent to the respondent number to the Assistant Commissioner Shumaga subdivision is set aside in respect of the land belonging to the petitioner to an extent of 1 acre 34 guntas in survey number 186/9. Annexure.
Which is the petition of my application.
That's correct. In that way of the matter, the endorsement dated 13/12/2022 within bracket annexure F issued by the respondent number 4 is set aside. Full stop. Order sheet alternatives. IA2 of 23 filed by the petitioner is accepted. Petition is permitted to amend the writ petition accordingly. You can do it now. Yeah? You filed it out. Amended and the amended petition shall be filed. You can amend it now. In that way of the matter, as the annexure F to the writ petition is set aside, who has to consider? Respondent number 3. Whether it has been made as part. The respondent number 4 is hereby reconsider the issue afresh in the light of the observation made above. The fourth respondent shall pass an order accordingly within 3 months from the receipt of this order. 4 months, sir. Within 6 months from the receipt of this. Along with CP, served copy to the other side. Annexure A. Annexure A is challenged. Yes, sir. Just 1 minute, sir. Just. Yes, sir. Yeah, they have sold to you. They have sold this property. What is over? Now you can implement. Now you can implement in the sets. Total. Who? That is no. That is between the parties to the proceedings. No, you are. No, you are not a party in the annexure A. No. Maybe true. What will happen? No. The suit is between the revision of petitioners and the respondents in the annexure A. Sir, they are the petitioners. They are the plaintiffs. Lakshmi Narayana. Venkata. Even in no. Let us will see the subject line. Whether subject line is belonging to the suit schedule property. No. Where is your sale deed? Annexure B. Annexure G. Page 61. Just 1 minute. 22. Just one minute. 1 minute. Survey number 35/6A3. But the subject land is there. You can implement. As well, you can implement. Because the subject, no. The thing is, survey number is one and the same. And the suit is for declaration. Then 71. Based on the sale deed, it has been now. Let the notice. Because already the MR has been affected. Based on the then at EG accept notice for respond number 1 to 3. Issue emergent notice to 4 to 7. In the meanwhile, the parties are directed to maintain status quo insofar as the revenue proceedings are concerned. Sir, copy to the. Sorry. Then at AG is directed to sir copy of the petition to the Sri Chandrachud A. Then a council appearing for the respond number 1 to 3 and Sri HV Devraj for respond number. Sir, copy. 2 weeks for 20. 2 weeks. Yes. Yes. Lebanese sketch. That's a division bench chart. And no. How would you say that it is required now? Lebanese sketch is not required for execution of the sale deed. No, there is a division bench judgment and Arvind Kumar Saibrudu ಸಾಹೇಬ್ರದ್ದು ಇದೆ ಒಂದು. But now you are not abiding. That is up to you. That is up to you. That is a law declared by the division bench, and subsequently we are following. I think Arvind Kumar ಸಾಹೇಬ್ರದ್ದು ಒಂದಿದೆ. Thirty. ನಿಮ್ ಪಿಟಿಷನ್ ಅಲ್ಲ ಕೊಡಿ. ಸತೀಶ್ ಸತೀಶ DJ 24987 ಅಲ್ಲ. One minute. ನೋಡಿ. That is on the point actually. Detail on. But I have folded it. Yes. Follow this. Follow this. In all these all these petitions. In all these petitions. Please sit down. In these petitions, the grievance of the petitioner is with regard to seeking direction to the respondent to register the sale deeds without insisting for furnishing the 11E sketch within bracket, 11E sketch bracket, survey sketch within bracket, close the bracket, full stop. Notice ಆಗಿದೆಯಲ್ಲ? ಆಗಿಲ್ಲ ಅಲ್ಲ? ನೋಡಿ, ನನ್ನ AG accept notice for respondents. Yes. Having heard the learner counsel appearing for the parties and on careful examination of the prayer made in the writ petition, the division bench of this court in WP number 18939/2009 disposed of on 18/3/2016 and the order dated 2/1/2017 in WP number 65235 of 2016 dated 2/1/2017 and the order passed by this court in WP number 24987 of 2018 disposed of on 15th June 2018 within bracket annexure H in WP number 13040 of 2023 directed the respondents therein to register the sale deed in respect of the property described in the sale deed without insisting for production of 11E sketch within bracket survey sketch subject to the petitioners complying with all other requirements as prescribed under the Act and the registration rules for registration of the sale deed. Full stop. Following the declaration made by the division bench of this court and the orders passed by the learned single judge in the aforementioned writ petition, I am of the view that the writ of mandamus is issued to the registering authority not to insist for 11E sketch insofar as the registration of the sale deeds are concerned. Accordingly, the writ petitions are allowed. Yes. 1 minute. What is your legal right? Then that's why you have no legal right. That's why you don't have a legal right. This court in 2011 say that it cannot be accepted. Even that cannot be. That cannot be considered. Because you have no existing legal right. Since you are in unauthorized occupation. Even that cannot be done also. Yes, consider it. Under AG except notice for respondents hearing. The grievance of the petitioners is with regard to consideration of the representations. Representation dated 2/7/2020 within bracket annexure D. Without expressing any opinion on the merits of the case, the respondent but 2 shall consider the same in accordance with law with an outer limit of 4 months from the receipt of the same. Accordingly, the petition is disclosed. Yes. Pass over. Pass. Yes, sir, yes. Issue 11 is related to land. It's 2007. Yes, sir. Endorsement is already issued. Issue notice letters. No. Have you considered his representation produced at annexure D? Total. We will see what he will say. But okay. Friday. At the request made by the learner AG list on Friday. Yes. 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 What your challenge? That how you are agreed by this? Yes. But anyway, the suit is pending. Yes. Yes, facts. What's the facts? Anyway, following the division bench order and the contempt petition order has been passed. Yes. What is the suit? Yes. But already the division bench of this court is held against you. That's correct. Even the division bench in 2021 itself has stated. No, go to paragraph 6. Tail deed that is executed by the vendor of the petition.
And the mutation was affected in May 1983 itself. And I think in the position that India had applied in proper. And I followed the bidding orders and it is fact. And based on the orders, pricing, the mutation has been reverted back to May. And I don't think
Let us. Yes, do one thing, establish your right. That you will establish its right. You cannot interfere. Anyway, you file a suit, get it converted into a declaration, and prove your title. No, but already the division benches are held against you. You suffer 30 guntas of. But on the other hand, to the extent of claim dam by HNCR's revenue records has been mutated, the light of which came to pass by the Leonard single judge, staying the further proceedings which relates. Sir, in the event if you interfere, civil court will take care of. But out just 1 minute. Allow him to say. Please sit down. No, how to get over this order now. Clarify only the division bench has to clarify. I cannot clarify by taking into account your submission. 44. No. No, what is it? No, the Assistant Commissioner says second respondent who have played a fraud before the authorities not enter for any revenue. Yes. Whether the revenue authority can say that you committed a fraud. That's why the Deputy Commissioner has reversed it actually. However, it is made clear that the order is subject to the outcome of the pending cases before the High Court and the Court of and the Civil Court. Yes. Who filed OS number 1965? Establish your right in this sense. That is what. But looking into the finding recorded by the Deputy Commissioner, I think yes, rightly interfere with the order passed by the Assistant Commissioner. Even the division bench is also insofar made an observation. That's Yes, establish your right, just I will follow. I have to follow, I'm bound by that also. I cannot say it's not an order. You may say rightly, but I cannot say. It's a division bench order, I am bound by that. Anyway, here also the 19th OS 1964 to 19 is established right in the. I cannot go beyond what. Yes, sir. Yes. 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 Anyway, the division benches already made an observation. I cannot traverse that. Anyway, the deputy commissioner would say that we establish a right in the. Let us wait. Yes, sir. Cannot say that don't interfere. All those things in revenue. Yes. Yes, sir. Told you. Code is done. Subnumber is also. Then established. Told you. Precedence. Heard the Lana Council. Heard the Lana Council. Whether notice is order, notice is issued. Notice is issued. Notice is issued. First time or notice is issued. Please sit down, sir, please. Again. Notice is not order. Then at EG, accept notice for respond number 1 to 4. 1 to 4. She B.N. Muralidhar, then a council entered appearance as caveated for respond number 5. Heard the Lana Council, please run. Heard the Lana Council appeal for the parties. In this petition, petitioner is assailing the order dated 1/4/2023 passed by the second respondent hearing in RP number 124/2022-23 within bracket annexure A and sought for confirmation of the order dated 27/1/2022 passed by the third respondent hearing as per annexure B to the petition. The relevant facts for adjudication of this petition are that, the petitioner claims to be the owner in possession of the site number 1 and 2 measuring 18,000 square feet formed in survey number 56/3 of Hennur village, Bangalore North Taluk as per the registered sale deed dated 28/2/2013 within bracket annexure C. It is contended in the writ petition that the land bearing survey number 56/3 of Hennur village was originally measuring 1 acre 22 guntas. 20, they contain 1 acre 22 guntas owned by one Puttanna who had sold the portion of the scheduled property to an extent of 30 guntas in favor of one Muni Nanjamma as per settlement deed dated 8/7/1968 as per annexure D. Thereafter, the said Muni Nanjamma had sold the property to one Narendra Babu wide registered sale deed dated 17/3/1994 within bracket annexure E. It is stated in the writ petition that the said Muni Nanjamma, comma, the mother of the respondent number 5, comma, though as aware about the sale of the land in favor of the third parties and comma, however as executed the release deed in favor of the petitioner herein as per the release date dated 21/6/2007 within bracket annexure F to the in favor of the petition, but you stated petition in the sixth petition in favor of the respondent number 5 within bracket annexure F. Full stop. That's why I said how, but in the writ petition is stated in favor of the petition. No. That's your writ petition I'm saying. You say in favor of. Go to paragraph 6. Wrongly you stated to the petitioner. That's why I said how the mother will execute instead of son. You read paragraph 6, your draft. To the petitioner, you say. Full stop. Within bracket annexure F to the writ petition. Full stop. However, on careful examination of the paragraph 6, it is indicated by the petitioner that the release deed has been executed in favor of the petitioner, comma, which is not correct. Having taken note of the factual aspects on record, comma, undisputably the release deed dated 21/6/2017 as per annexure F has been executed in favor of the respondent number 5 by the said Srimati Muni Nanjamma. Having heard the Lana Council applicable parties and on careful examination of the finding recorded by the second respondent hearing as per annexure A, wherein, comma, the respondent number 2 has taken note of the findings recorded by this court in CCC number 249 of 2020, disposed of on 17th April 2021. Paragraph 6 of the order passed by the division bench reads as under. Having taken reads as under. Next step. Having taken note of the finding recorded by the division bench of this court in the aforesaid contempt proceedings, and also it is not in dispute that OS number 1964 of 2019 passed by the petitioner, comma, filed by the petitioner is pending consideration before the competent court, and the said aspect has not been disputed by the Lana Council appearing for the parties in the present writ petition. Matthew, that there is no interference is called for insofar as the order dated 1/4/2023 passed by the second respondent hearing. However, it is open for the petitioner to establish his right over the scheduled property before the competent civil court in the aforesaid. Accordingly, the petition is dismissed. Yes. Yes. The mandamus direction to the grant land. How can you? No, your prayer is to grant land. Direction to the respondent to grant land bearing so and so. How can I direct by way of writ? File representation, let they will consider. That I have seen annexure D. Subject to the payment earlier, 12,000. Correct. But if you look at your legal notice, but you are running a education institution in the granted land. You are running a education institution in a granted land. That's why I said make one more representation. Granted, subject to payment of 12,000.
Yes.
That you are not complied with.
Mind the amount of
Let
payment of
this order was passed in 1996. What has happened subsequently?
subsequent on this all that.
So subsequently, what has happened?
Nothing. They have been,
Have you approached the concerned authority? So take for an example.
Yeah.
But 1996, since you have not done anything.
The order never.
Yes, I read it. Just I will do. To the Assistant Commissioner. No. No, what they are saying, instead of you approach a deputy commissioner, you approach assistant commissioner. That's all. In the event if you approach, they will consider it. That's all. They will take. No, but in the notice, you stated that you converted the land into education institution. That's why I said, in the event if it is considered, then it has to be not even 1 inch. 1 inch of the land cannot be utilized for. No. Let they will consider. Let they will make a representation. Assistant committee you consider. Sorry. But this was in 1996. Then I have to. No, but I have to dismiss that 96. Now you are approaching in 23. I am to dismiss on the ground of delay. See, this order is passed in 1996. Then after 17 years, now you are saying the very same authority will. That cannot be not correct. That's not correct. Sorry. Whether notice is issued? No, it is heard. It is the notice is issued. Maybe we will hear, but notice is. Agreement. Agreement. Section 23. Notice matter preliminary so on. Heard the Lana Council appearing for the parties. So, Lana Council Sri Keshav Bhatt appearing for the petitioner. After argued that the respondent authorities have to implement the order dated 28 June 1996 passed by the Karnataka Appellate Tribunal Bengaluru in appeal number 340 of 1994 within bracket annexure B insofar as the land which has been already granted in favor of the petitioner by accepting the necessary charges. In that full stop. Per contra, Leonard AGA so and so submitted that in view of section 23, rule 23. What do you mean? So, Leonard AGA, yes, bringing to the notice of the court the amendment effected to rule 23A of Karnataka Land Grant Rules 1969 dated 8/3/2023 and submitted that the petitioner has to approach the jurisdictional assistant commissioner of the subdivision seeking consideration of the prayer made by the petitioner. That view of the matter, but view that in view of the amendment made to Rule 23A as per the notification dated 8/3/2023, the petitioner be directed to approach the jurisdictional, the assistant commissioner seeking redressal of his grievance. If such a representation is made by the petitioner to the jurisdictional assistant commissioner, same shall be considered by the said authority in accordance with law. Within an outer limit of 3 months from the receipt of such representation. 6 months from the making of such representation by the petitioner's hearing. Yes, sir. Records have been. What your assortment? So annexure F. Just a minute. Whether notice is issued to the petitioner? Huh? What's the record says? Records, not. I said records, you produce record pertaining to the 295 of 2007 and 8. Where is the record? Huh? Produce record. What is? See, the argument advanced by the petitioner was not no notice was served. Where is the records then? Then he shall be present. He shall be produced. He shall present. Third, this court. Why records was not given to you? This court, by order dated 30th/10/2023, directed the Leonard Additional Government AGA to secure the records pertaining to the land in question from the respondent number 2. However, no records have been produced today. In that way of the matter, the respondent number 12, which is the impugned order. Just one minute. Next year, F. F is the assistant commissioner. Respondent number 3. Respondent number 3 shall present before the court with the records by next date of hearing without fail. Failing which, coercive steps shall be taken against the respondent number 3. Let this matter on when? Yes. That letter. Annexure K. You are the respondent there. Yes. Annexure H. Just 1 minute. That is revision petition 31. Before the deputy commissioner. What happened in that proceedings? Annexure K. Hmm. Correct. Annexure H and annexure K are one and the same.
Same order. No, here you are.
Which is earlier order?
Here.
40. Sir, that is a petition copy. Ah. When they were earlier. Where is that order? Same order means which order? Annexure 45, sir. Deputy commissioners. Who are the petitioners, sir? So that is Venkatramanappa, Venkatesh and Anjanappa. They are the parties before this court. Then our party illa illi. Maybe responding. Not adverse, dismissed. So when the respondent is there, dismissed means in their favor. If the respondent is there, dismissed, that means in their favor. Yes, what is the best ground for you? Best ground urged in the petition. Yes, sir. Correct. Anyway, OS is pending. ದಾವಾ ದಾಖಲಿಸಿ ವಿವಾದಿತ ಸಂಬಂಧ ಮಾಲೀಕತ್ವ ಹಕ್ಕಿನ ಘೋಷಣೆ ಮತ್ತು ಇತರ ಪರಿಹಾರ ಕೊಟ್ಟಿದ್ದಾರೆ. OS 1520 ದಾಖಲಿಸಿದ್ದು ಅದನ್ನು ಮರು ಮಂದರಿಸಿದ ಕಾರಣ. It is filed by them. Then what's wrong with this? Suit is dismissed. And suit is for declaration, seeking declaration. Yes, sir. Sections. Yes. Yes. First of all, 5 years delay in approaching and 28 years in original. On program. Sorry. Objections you have filed? 2002. Where is the judgment and where is the order passed by? Just. So plaintiff's annex, page 25. To declare that plaintiff Gullappa Y.N. Srinivas, his father, Pankarish, already filed, suit, dismissed. Third. The notice is ordered or then at AG accept notice for respond number 1 to 4. Shrikant entered appearance. The concerned Shrikant entered appearance as for K-waiter / respond number 5. 5, 6, 7 also. K-waiter for 5 to 7 respective. Please sit down. In this writ petition, the petitioner contended that the land bearing survey number 6, measuring to an extent of 5 acres 2 guntas at Yedugondanahalli village, Vaskote Talo, belonged to the grandfather of the petitioner as per the registered sale deed dated 6/6/1950. Please note 6/6/1950 within bracket annexure A. It is stated that since the date of the purchase, the grandfather of the petitioner was in possession of the scheduled property. It is also contended in the writ petition that the revenue authorities have wrongly incorporated the name of the respondent number 5 and one Dodda Venkata Ramanappa within bracket father-in-law of respondent number 5 close the bracket, and the petition came to know about the same as per the endorsement issued by the revenue authorities produced at annexure B to the writ petition. It is also mentioned in the writ petition that the petitioner has approached the respondent number 3 in RA number 58 of 2018-19, challenging the incorporation of the name of the respondent number 5 to 7 in the revenue records. The respondent number 3 by order dated, where's the Assistant Commission order? By order dated, yes, 24/4/2018 within bracket annexure E, accepted the petition filed by the contested by the accepting the said petition in RA number H of 58/2018 filed by the father of the petition hearing within bracket annexure E, and as such, the mutation in IHC number 115/19-91 was set aside. Feeling aggrieved by the same, the contesting respondents herein have preferred revision petition number 31/2023 under section 136 class 3 of the Karnataka Land Revenue Act. And the second respondent hearing by order dated 31st July 2023 within bracket annexure K allowed the revision petition, and as such, the order passed by the third respondent hearing as per annexure, passed by the respondent number 3 was set aside. Feeling agreed by the same, the petitioner has presented this petition. I heard Mr. So-and-so Omkaresh for the petition, Mr. Lana Senior Counsel so-and-so for Mr. Srikanth for respondent number 5 to 7, and Leonard E.G. Sri Omkaresh, Leonard Counsel appearing for the petitioner, contended that the finding recorded by the second respondent hearing restoring the name of the contesting respondent in the revenue records is contrary to the records. Accordingly, he submitted that the said finding recorded by the second respondent hearing requires to be interfered with in the present petition on the ground that the respondents hearing have not established their right insofar as the land in question. Per contra, when a senior counsel appearing for the appearing on behalf of Mr. Srikanth for respondent 5 to 7, invited the attention of the court to the plaint in OS number 1529 of 2008, 1520 of 2008, before the civil judge within bracket senior division close the bracket Bangalore rural, and contended that the father of the petitioner hearing has filed the said suit seeking relief of declaration against the respondents contesting respondents hearing, and the subject matter in the said suit is relating to the survey number 6 of Yadadonhalli village, Hoskote Taluk, which is the subject matter in the present petition, and the said suit came to be dismissed, or no, he content dismissed. You cannot say default. He says dismissed, and they said judgment and they said dismissed as per the order sheet produced at annexure as produced at in the statement of objection, and same as reached finality, and accordingly he submitted that there is no interference is called for in this petition. Per contra, Leonard AGA submitted that the petition hearing has approached the third respondent hearing after 28 years, and the second respondent hearing after 5 years. And the said aspect has also to be considered in the present petition, and as the and he further and the Leonard AG further contended as the suit filed by the father of the petitioner has reached finality during 2015, and therefore sought for dismissal of it. In the light of the submission made by the Leonard Council appearing for the parties, it is not in dispute that the contesting respondents hearing seeking entry of their names in the revenue records as per the ISC number 115/1990-91, and the said order was challenged by the petitioner by the father of the petition hearing during 2017-18 after nearly 3 decades. It is also forthcoming from the writ petition that the third respondent hearing has passed an order on 24/4/2018-14 as per annexure E, and the third respondent hearing, has erroneously passed an order, taking into consideration that the suit is dismissed for non-prosecution on 30th January 2015. That is Martyrs Day. Martyrs Day, 30th January 2015, and no further action has been taken in the consideration. Having taken note of the factual aspects on record, as the suit filed by the petitioner in OS number 1520 of 2018 was dismissed on 30th 1 2015 as per the order sheet produced by the contesting respondents herein in the statement of objection, and further, as the petition's hearing has not established is their right in respect of the land in question before the civil code, and therefore the mutation entered by the respondent authorities in favor of the contesting respondent herein as per the IHC number 115 of 1990-91 is just and proper, and no interference is called for in this situation. Accordingly, repetition is dismissed. Bedu land take notice. Agile. What is the instruction that? Again. ಬೀಳು ರೆಸ್ಟೋರೇಷನ್ ಮನವಿಯನ್ನು ಸಲ್ಲಿಸಿದಲ್ಲಿ ಜಮೀನು ಅದೇ ವಿತಿನ್ 2012 and 14 next page sir. Yes. Can you consider it not correct? Anyway, is the owner of the land. For some reason, they have not paid. Now it has not been. Land is not been. Sorry. Please sit down. In this petition, petitioner is assailing the endorsement dated 19/6/2023 within bracket annexure yes issued by the respondent number 4. Inter alia sought for direction to the respondent number 2 and 4 to restore the name of the petitioner in the RTC extracts, substituting the word within inverted comma Bilu in respect of the subject line. Having heard the learned counsel appearing for the parties and on careful examination of the impugned endorsement dated 19/6/2023 within bracket annexures yes would indicate that the application made by the petition herein was rejected on the ground that the said representation has not been made within 7/12/2012 and 6/9/2014 before the second respondent hearing. However, perusal of the record would also indicate that though the land in question has been as it is evident in the record of rights that it is Bilu. However, the land in question has not been forfeited by the government. In that view of the matter, as the petitioner herein has already approached this court in WP number 12226 of 2022 within bracket annexure K disposed of on 14 July 2022. I am of view that the reasons assigned by the fourth respondent hearing cannot be accepted as the land has not been forfeited to the government and the land in question is in possession of the petitioner and is in cultivation of the same. Accordingly, the impugned endorsement dated 19/6/2023 within bracket annexure yes is set aside. Passed by the respondent before is set aside, and the writ of mandamus is issued to the respondent number 2 and 4 to restore the name of the petitioner in the RTC extracts insofar as the land bearing number survey number 39 to an extent of 4 acres 31 guntas situated at Kolangi, Abburu, Mallipattana, Kolangi, Abburu village, Kolangi or Abburu village, which village? Kolangi village, Mallipattana Taluk, Arkalgud Taluk, within 3 months from the receipt of this order. List. Accordingly, writ petition is allowed. 3 months. 3 months. Akash Kumar Gaud. Yes. Yes, sir. Let the notice will go. And at AG accept notice for respondent number 1 to 3. Issue emergent notice to 4. In the meanwhile, stay of annexure. Stay of annexure G dated 26/9/2023 in RP number 233 of 2022 on the file of the first respondent hearing till next attack. Who has to consider annexure F? Who has to consider annexure F, sir? Yes, sir. You say that your name has to be entered in the RTC register. Now, what has happened now actually? Oh. Now that has to be challenged. Challenge challenge under 136(2). No, instead of that you challenge the thoroughly. Then it no challenge. It is a futile right actually. It is a futile right. Just a minute. Leonard AG accept notice for respondents 1 to 5. The petition hearing sought for consideration of the representation dated 12/10/2023 in bracket annexure F by the fourth respondent hearing. Perusal of the petition would indicate that the fourth respondent hearing has mutated the has changed the mutation as per the order dated 24/8/2023 in MR number MHH2/2023-2024 as called out in the as reflected in the annexure F. In that view of the matter, without expressing any opinion on the merits of the case, petitioner is having a remedy under section 136, clause 2 of the Karnataka Land Revenue Act, reserving liberty to the petitioner to approach the competent authority. Petition is disposed of. Yes. Taken up. Yes, sir. 40. What is this matter? 40. 40. At the request made by the Lana Council appealing for the petitioner, just after 2 weeks. What with Devraj? At the request made by the petitioner, this matter 2 weeks put on the interim order granted earlier extended till next.
May request, my lord.
Yes, sir.
My lord, serial number 43. The
Yes, sir.
government advocate last date taken for adjournment for instructions, my lord.
Yes, sir.
I requested.
That is yes. Yeah, received. No.
And any specific date may be fixed, my lord. Both are ready to
Let us will see whether that is sufficient to adjudicate the matter.
No, my lord. Senior counsel will appear, my lord. Therefore, my lord.
Yes, sir.
Senior counsel, Sri D.R. Ravishankar sir will appear. Any specific date may be fixed, my lord. Let them file an objections, my lord.
43 nalli. Leonard AGA seeks 1 week's time to file statement of objection. Accordingly, list after 2 weeks. That is
My lord, my lord, my request, my lord. Any date may be fixed, my lord. In
2 weeks.
40. Any
20.
date may be.
20+. Yes, sir.
Grateful, my lord.
41. 2 weeks. Next. 49. 49 serial number. The request made by the petitioner list after 2 weeks. What about the reports has to be filed by the government? But you have to file a report. Non-filing of that is 1 or 2 weeks.
Court officer, madam. Court officer, sir.
Yes. One నిమిషం. Next year A is challenge. June, it is an order passing June. File revision. Maybe no. Which under which provision the next year? ಜಮೀನು ವಹಿವಾಟು ಅದರಿಂದ ಭೂಜನ ಏನು ಗೊತ್ತಾಯ್ತು. Notice will go. The June order after 5 months. That was based on the Lokayukta. Now you are taking revenge by filing writ petition. Now you are taking revenge now. There could not be any revenge. So legal system is like that. Let the notice will go, let us. No, that is assistant commission order. No, let the notice will go. Let us at this juncture not. Let the Leonard AG accept notice for respondent number 1 to 3. Issue emergent notice to 4 to 14. Let us. There's a June order, sir. Let us will see. Let the other side will appear. Let us. No, nothing will happen. Anyway, the notice is issued. Nothing will happen. Sorry. Nothing. Let we will see. First of all, anyway, the revision is there. Of course, let us will see. Let us will see. Serial number. Non-filing of affidavit. Yes. Order is ready but not signed. Order is not ready but not signed means what? It has to be done. Can I go? Can I go there? Why? It's a precious signature. Huh? Huh? He is very precious signature and great person. This court twice time was granted. List this matter tomorrow, Mister. Who has to do that actually? He's so powerful man. This court by order dated 30th 10/2023 granted time to the Learned Additional Government Advocate to comply with the order dated 9/10/2023. And also it is observed that the ADLR Bangalore South Taluk should be present before it. Today matter is listed. Again, the Learned EGA submitted that the DDLR is busy, busy and he has not looked into the file. Accordingly, lead this matter tomorrow at 10:30. Unless the order is signed by the competent authority, coercive steps shall be taken against the official concern, and in the event if the order is not complied with, appropriate action for contempt shall be initiated against the competent authority. I had granted time at your instance. That's why now it has to be done. Serial number 30. 30 something. Now, what is this actually? What your challenge? Director is considered as a representation daughter or alternative. Respondent to assistant. 6 months. Not 6 months. No, 6 months. I will grant you. No, I will grant your prayer actually. I will allow your petition. Don't allow. You tell me, I will. If I record your submission, I have to dismiss. But I want to allow your petition. Nothing will. I will allow your petition. Not necessary. ನೀವೇ senior ನನಗೆ Learned AG accept notice for respondents. In this writ petition, petitioner has sought for direction to the respondent number 3 to dispose of the appeal filed by the petitioner under section 136 class 2. Done. 136 class 2 of the Karnataka Land Revenue Act. Without expressing any opinion, without expressing any opinion on the merits of the case, the third respondent herein shall consider the appeal preferred by the petitioner in RA within bracket S 54 of 2022 in respect of the subject line and pass appropriate orders within 6 months from the receipt of this. Accordingly, writ petition is disposed. P on. Yes. Ready. What is the fact set? Government employees house building. What your challenge first? Yes. 1 minute. It is 6 acres, 17 gunters. How much was acquired? 4 acres, 30 gunters acquired for the purpose of the petition society. GSS. Institution. Acquired for the purpose of GSS. Not acquired. Out of 6.17. Yes, sir. How much was granted to GSS? 4 acres, 30 gunters. That you look.
Various members.
Yes.
Members of respected posts. That's how we consider it.
Anyway, since it is not acquired, it's vest with the government. Vest with the landowner. Correct. Acquisition. It vests with the owners.
You cover in it.
But in the year. Respondent really bad. Approval was given.
On what basis you allotted the sites? On what basis you formed it, the and so far as allotment has been made? That's a different thing. Leave it. Since you are not it is not acquired land. 1 acre 27 gunters. Since it is not, no. What I'm saying, since it is not acquired.
Second point is, because these allotments who are actually in possession of their house, maybe they are saying, without notice, significantly. These are the only two points.
Yes.
It's not like the revenue code can extend the power at any point of time, or take it, go, then come and find out.
Now, no. What is the wrong committed by the authorities?
Then go already do that.
Yes. They are the owners. Sir.
They are revenue owners. Civil court you're saying that it is part of the limitation. Only has come. It is. But you know the revenue. My lords are saying it. My lords are saying that this kind of petitions are to be treated or allowed or entertained to stay. Then but they have found that I think I have. First, at that time, the submission was received by the
Same yardstick is applicable to you also. Same yardstick is applicable to you also. You are in the position without title.
I may be in possession without title, but a person in possession has to be protected. But the basic law, person is in possession, even without a title, can't be thrown out without following the due process. That's why we produce a number of them.
Give me two. Give me. No, you tell the n number of. I want only n null, one little sir. Okay. On merits, you can submit it. Yes. No. Only thing, whether you are intending to file civil suit or not. What the Muda would say on this? Not approved. CAT. Town planning area. Oh, it's not part of the levy. 57/1 is not a part of. Let us see. Yeah, ready. Now you said, now you argue when you are going to do. The request made by the Lana Council appearing for, or the Lana Council appearing for the petitioner for some time. Lana Council appearing for the parties, and the Lana Council appearing for the petitioner seeks short accommodation to make further submission in the matter. Next week, 2:30 for further hearing. Any day. for the convenient of the Lana Council for the petitioner, list on 22nd. 22nd at 2:30 for further hearing. You hear him now? Ah. Just a minute, 1 minute. Maybe I'll call him. For the Lana Council for the parties on IA 1023 filed by the impleading applicant, excepting the reasons stated in the application accompanying affidavit. IA 1023 is allowed when a council applying for the petition is permitted to amend the cost item, and the impleading applicant shall be arrayed as point number 7 and to file the amended cost item. Interim order granted earlier, little 2:30 for further review. Um, 47 yes. Yes. The internal order is challenged. Actually, yes.
Chairman.
Yes. Yes. It is 79 A and B is prospective or irrelevant? Huh? From the date on which the purchase was made. Surrender. That's good. Correct. So 366 by the members. And insofar as the minority views, so three. Page 43. Page 43 ಅಲ್ಲ? Page 43. 47. Considering all the documents. Considering all documents. Yes. That was, what are the questions formulated by the army? Let us be come from that. Where is the order passed by the Supreme Court? Honorable Supreme Court. Now we cannot go back. According to it, cannot we go back now? So this is the order passed by the army. Yes. 260. Yes. Yes. Now what, just before adverting to the release, what was the original order, land tribunal? It is 223. That is a learner single G. And that is a review petition. What is the original order? Because the sequence of 216. Just a minute. This is the first order, 7th November. Just a minute. So that is prepared by yourself. Claimants. Two one. Other by the state. 10920. Yes. Take it up so that others can need not. Yes, sir. Others need not wait. Other petitions. Remain. They didn't know. After 1 week. It will take long time. You need not wait. Yes. Next week. Friday. Next. Friday, a lot of matters. Next. Even no. Post. Yes, sir. Adro. Bit of madam. Date. Yes. 22nd. Declares. Yes. 60. So that only this matter will be there. Yes. ನಾವು ಮಾಡೋದಿಲ್ಲ. Yes. 220. Yes, now we can. Yes. The original order is 27,982. That's then it was plant. Today is tree. Then it was plant. Today is a tree, big tree. They did not allow you. Cardamom today. Yes. 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 September it will be there. That's yes. Yes. In view of that dismissal of the writ petition by this. Yes. Yes. The writ petition is already urged. Anyway, for 368.16, you're ready to. Writ appeal was filed. Direct. Yes. Two 6-0. Yes.
In the project, it is more holding the value.
So 79B is not applicable.
I think what is right now because there is nothing.
Under 4,
This is like what more equal to the vast extension. Cover plantation.
yes.
But there is a factor which is not being clarified for us. And I think Congress is not much stronger.
Yes.
The land created under planting is all erased.
If it is that 79 is applicable only if it is agriculture. But otherwise, if it is held to be plantation, then 79 maximum would be the insofar as the ceiling limit.
In fact, a strong belief plantation that is some because when research from company, everyone can hold plantation land and then go up, right?
Correct.
Tata Coffee moves the company. Right? One of the main grounds is the people. There's a very good people. If you want only the terrain, if you do this, you will not have. And the radius is like what we we got the result very, very, very. Subject one to. Well, without determining how all the style got transmitted,
Yes.
Forest land, not country. This is not land as a forest land. It is a forest land or as a forest. This forest land is a class A forest land. Ultimately, the leading lesson is the it's not private forest land. Private party is full forest. I did not reserve forest or declare forest, nothing of that. So I'm not there notification, but if you are the legally flag. So it's not clear that it is forest. That's one. What? Right. Most properties can be only the road. Alternate can be the forest land still recognizes that those lands can be utilized as
Loses its entity. As a forest, it loses its entity as a forest land.
why is it not the fact that it's forest? Not in that area. Area is not annual. Some portions not big organization. How to take that? Kerala is one key forest land, another one is Madras forest land. That's not why it's not good. They're not taking it. That it is cultivated, it is legal in that.
Land reform or a filling
Not
plantation.
Kerala not specifically key. Also, where is what happens to the plant? Kerala also some plant is not the thing. So, someday they will do an action for Kerala, but if Karnataka allows for the case. The issue is getting really difficult. The answer is there in the different forest. I'll show you what is the different forest. It makes it clear. I think the issue is what that question is answered. Very deep. Forest. Also, my right is there. It is not exclusive. Indication not the forest that is contained in this lot.
Yes.
Can work regularly. Meanwhile, no owner in forest has without the previous action of the coming sell mortgage lease or otherwise DNA the whole of the
Yes, private forest.
No, exactly. This is the Karnataka. This is why and therefore, forest land is purchased, how did it become cultivable land? Again,
Now again we have to classify private forest and public forest. Private means a regular forest, reserved forest.
It is not an issue. It is not an issue to the state. That is not this forest like six forest or eight forest or reserve forest, but it is not a forest like
Yes.
what no the I don't understand.
Or plantation. Plantation.
People started in that, they got go. So far,
Okay, even this act is not applicable. Even 79 ABS. Yes. Plantation.
The larger concern of which one example.
But for that only it was remanded.
Entire land value. Then we can find the fact. The majority view is what covered the land. And was not what understand all the land, all the land. Let's say the only thing land is all the same. That is the thing I asked them. The company is not impacted with money. We did not demonstrate by all. Under the measures for a site, there is some prohibition of these buildings that this is not the case. They are not there is one ground about it. But it is that is not very general. I will say this to you. It's not so that you don't have activity. It is not a good policy, but culture of plantation. The question what
Yes. Yes. 60, page 60. Proceedings. Forest. Yes. Reserved forest. Yes. Yes, sir. Yes.
Right, owner.
No, no, I'm good. Where it is? Yes. Karnataka Forest Reserve. Everything. Everything. One minute. Karnataka Forest Reserve. Where is it?
This is about background before the electric draw. After Karnataka got to see,
Correct.
the Heravi forest. This is not the draw of state to the left, is another Heravi forest.
Yes.
Pressure is Heravi forest. And here, what is the corner? Area cardamom estate.
Where is it? Where is it? Right page.
Heravi cardamom, area cardamom estate.
Area cardamom. Yes. Yes. These are where the subject matter land is. So this land was never identified as classified as a forest.
And the middle forest is forest, state forest.
Yes.
Why I want to tell here, there may no policy. But it is not the case. These are the mankind in they know what is land take that. You know, it is the position.
And so for that ground is concerned, unanimous.
Not denied. So I think what is land? The audience content is in the audience. Not a point, and you're not giving them. Plantation is not because over the area which is taking a plantation for the command there. All the children gated. What is forest land? Independent land, what can be the forest? And then turn out to go forest land is the. It's planted, but actually right in the same. But it's not forest land. Basically, what is starting. How much
Can I say that you're not disputed that it's a no, I have to. No. The reason for remanding the matter to the Tahsildar by the Honorable to determine whether it's a forest land or plantation. See, that was prompted. Yes, sir. Yes, Mr. Danchina. That was prompted the Honorable Supreme Court to remand the matter to the. Now, in the event, if you say it is, you are not saying that it is a forest land. Even it answers even the. Then the Supreme Court is even.
Because the Madras Association private what is that? They had purchases there and they are holding it. But there are certain things which they have not fulfilled. Subsequent to the reorganization of the things, not being granted the votes. There is a final. Subsequent.
If I just I will clarify myself. So what prompted the Honorable Supreme Court to remand the matter to the Tahsildar to determine whether it's a reserved for a forest land, that means reserve forest, according to you, or whether it's a plantation. In the event, if you say that if I record a submission that your plea is not, it's a forest land, then that answers all the Honorable Supreme Court to that extent. Yes. Only on that ground it was remanded. If you say that, yes, yes. Yes. No, just you pause on. Anyway, to that extent, in fact, I am clarified. Now, 114. Two lakh 70. No, 114 is sale date 2,75,000. 2,74 in 1899. 1957. Certificate under so and so 1957. Even now this is huge. Yes. Apply to the collector for South Canara for permission. So and so. Whether permission was granted? Granted a permission to the vendor for sale of so and so under reference so and so. Whether you have the copy of the 3112. They are not disputed. Yes. Next. Yes.
At that point in time, Cardo started area shown at page 120.
Yes. 50.18 mean.
50.89 is the population.
Partially clear, so and so unclear area. 3485 acres.
At point in time. So,
Result.
in this context, you want to see urban planted area, copy area, tree, and you get the ultimate kind of country. That's the best. We have the copy plantation. But when this document and this document will determine our area. So this development. Development is very obvious because even in water as well as basically, he notices he can
Yes. Yes. Father certificate.
Four
4028. Yes. Correct. With cardamom 2500 acres. With other crops and so on, so it's 23 acres. Yes.
4.75 is there.
Ah, it is out of that 4,000.
The record price. Okay, 172. Extent not a mention. And you cannot.
Yes.
2,500.
Yes. Cocoa 100, rubber is 2.
The
Eleki. No, it is Eleki. 2,500. Cocoa 100, rubber 220. Yes. 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 2,500, 220, 10. As per RTC.
That portion and give it a big result. Obviously, not that is also required because next. Inspection.
Yes.
Cardamom is 2,500. Rubber plantation is 20. Cocoa is 100. Rocks, so everything is really expecting the entire extent.
Yes.
Contemporaneous point in time. We are not. What is the situation? How many of these are there in the cardamom plant that is that?
When it was
Not,
no, just I want to know before the order passed by the Honorable Supreme. Land Tribunal first. Before the order passed by Land Tribunal.
these people are big 146.
146.
146. The argument of this, I expect the land. In 146.
Yes.
And if it is that, Kerala is going to be really. Next stage.
Probably during 74, 75, during the LRF matter was going. Around. Anyway, that was much before the observation of Charles. Yes.
Then there is other case, by the reading.
Yes. Cardamom plantation.
Carbon plantation or because man cocoa, rubber, cocoa. What
Yes. So this was the first order, annexure R12. Certified by land tribunal. The order, so far as writ petition preferred by the state was dismissed. Writ petition dismissed means it is confirmed. Confirmed. Not set aside. This is against this order they went. Single owner, single judge order. Review. 82 means 27,982. Just leave. We go to the Honorable Supreme Court order. Please stand allowed in the above terms. Improve order if mention. We direct the proceedings under applications of said to be completed in accordance. Tribunal order original and review by 16/7 is 27/9. That is, this is 27/9. It's 27/9. Number is 167. That's how seen. These things will happen. Correct. That's how seen. Confirmed in WP was set aside by in SLP, Supreme Court. Yes. Yes. Ah. 188. To the extent of 368.2. Anyway, for that you are ready. Even that you are ready. That's right. Then the respondent hearing have appeared in SLP, but you did not say that it's a reserved forest. That's a forest. They thought that probably it may be a regular forest. Yes, sir. Now we go to the tuned order. Okay.
Today I asked, if all this is under and said, I will go back and make an assessment today. And today I don't see other startup. Because I don't see other startup, then we not even startup. Here. To go back. That is land is converted into building there now.
Yes.
It's never copy, therefore you cannot do the land.
Yes.
That's practically what you're saying. Today I don't see cardboard, therefore you cannot even cardboard on that. I only respect this from. But assessment is 74. And assessment of 74 is a problem. At that point in time.
Relevant.
After areas in Bangalore, not free if so many areas, there must be now. The occupant rate is granted, must be there, there will be so many different areas. And that one is not.
Yes.
The dissenting opinion is the it comes to 845
Normally.
on the forest issue.
Normally. See, dissenting opinions normally. See. Yes. Another important document for our.
Proceedings to follow the Supreme Court. The regulation. It is a detailed inquiry to land factor for the court. So it's not clarification very important.
Private, now they made it private deemed forest. Where is it? Where it is defined private deemed forest. No, you must know what is private deemed forest.
You are already taking something under the Madras forest, private forest there, private forest.
That's all. Deemed forest.
So, because the forest, of course, and the entire land of the government.
Government. Correct.
The entire case is only section is private forest. That building has been changed from 1957.
Yes.
So the
Next.
So over there,
You must visualize the 74, 70. Even 57.
is the one cent of land. This is forest. Otherwise, I have 1 cent of land.
True.
But he said I should take so much of land. Ultimate conclusion that I take so much of land.
That cannot be. That's
There is no way in law in which it was justified except by making this all claim unsupported by any materials
yes.
or unsupported by any issues brought which arose before the land management act. To make a determination as to whether this is only
Yes.
we need to produce road and it is one so this land has been declared to be a reserve forest.
Yes.
And people are transacting with it is illegal and therefore you cannot transact with it anymore.
Yes.
Because it is reserved for us. Then I ask you to bring it. If no notification, if there's no notification, how can you need that land? The portion land is given to the another person.
What was his conclusion? To what extent?
His conclusion was this, like a detailed 324 acres.
According to 3015 is a surplus. And is to be vested with it. Why 3? If at all is such been the case, enter 40 and odd is 4020.
Other areas it takes 48 money.
Yeah.
That area one is good. Because here 92 acres of cocoa plant, 36 acres of 92 of rubber and 36 of cocoa. Apart from other ones, there are edible plantation land that we will be. And the remaining area is surplus and surplus come back to the power.
Yes. It does not make it. The entire 4020 has to be forest area. Only to the extent of plantation is a forest. Remaining cocoa and rubber will be not a forest area. That cannot be. Ah. No, that was a minority view.
I don't. Most stretching management, I can't be correct. First, he refers to something impossible. And he then gives me land. And then I entitled to land, but it was reserved for something private.
Probably prompted, remanded by the announcement. Huh? Yes. Anything? Any judgment you want to refer or something else? Correct? Yes. Correct. Yes. Definition of private forest. Where are readings? 12. Order. That is vesting. 2A vesting act. Ah. Excluding.
So there also, it's like how much they're all then we say
Yes.
There's not a whole bunch of decisions in there with respect to whether it is a heaven land or covered countries.
Yes.
Each sentence
They are also saying that it's a forest.
is not the right and no specific. The land is ultimately translated to the sea.
Yes. Bharat? Yes. Yes. What is the proposition? Relevant pair. Ah. 38. This percent. Yes. Ah. Next, the per name is very.
The question of whether it is related or related, because that question actually answers this.
Anyway, 79 AB is not applicable.
Then you answer. That is on 66. There is no wrong.
Yes. Yes. Reply. Hey, where is the error committed by the land tribunal? 3 zeros. Yes. Correct.
Not adequate enough to be not to be supporting.
Then where did you get it? Acres of forest land. Yes. They say that it's a forest land. That's what. You did not say forest land. No, they said cardamom, rubber, or something else. Balance.
Forest is not our own creation. There is the same thing. You will have to track over. The only thing is one of the attachments forest or only a part of this house.
Yes.
Things are taking the in observe that they are cultivating every cardamom. One cardamom. Cardamom the whole is also one thing. They can maintain the detail of the after who very good cardamom. Was purchased by a court and the declaration permission letter to purchase forest has not been released at the time of buying the material. As per the above, permission to convert the forest into plantation has not been given.
Sell mortgage or something.
This is 1,227. Page 37, the last line, after the last order dated to the 90 days. Citizens are declared as per 24.
837.
Yes.
Yes.
Because plan entering item number 3. On the papers are declared all.
Yes. Which? 32, not 37. No, 37. It is not there. 32. Ah, yes. ADA, yes. DDLR and Assistant Commissioner. Yes.
And not for the area, the dialogue is calculated in not subplot. In between these some area, we have started dialogue.
That was the date on which inspection was made. Ah, surveyed from 20th May. Yes. Whether that is a determinative factor.
Area was right from the date of purchase. Indicated the more kind plantation at all. It is not their case that they had gone for, I don't know, means a copy of the very well shared.
We never,
They are not so whether it's because of That many situation happen. Only of the kind of only indicate that every kind of is not plantation effect. Not that I'm not why you don't have a more? Area being a solution of different right of the day they protected it. And there is no reason to get any. If that one, if there was no cardamom or only scattered cardamom, this be found. The regular had to confirm that there was no cardamom, this was not a plantation time at all. The regular would hold it otherwise.
Yes.
The continuation of that word. As for the ground facts, is also changing it. The deadline is still important.
Nature.
What is the of there is a survey, narrow system of zones. Now, coming is sector. If you only get given estimate, what is the area of land, if they found under cultivation and it was as there will be more cultivation.
Yes.
First one, rubber plant, you know, on the right side, the north side, the extent. Last, the head one, the remaining land is.
3117.
Kerala's view was go to this extent of 2000 and order to get and the excess land which is not plantation, is living income. Remember to go otherwise, not taking these into consideration. They would go by a different measure. So here there are cultivation land, plantation or plantation blocks,
Yes.
they are not lands, which they make us land, which they are. This finding is incorrect is my purpose.
Exceptionally to allow the reputation by the state. Huh? Normally. Pardon result. Yes. You can get a copy tomorrow. Give it
70.
1 inch. Or mark. Or 70.
17. Is like how much is gone?
This is the Ministry of Commerce. Technical report on cardamom plantation. Damage and extent of damage is too severe. Where it was in 1983 itself.
Tomorrow I will. Topic was there. Where is the carbon from?
After 50 years, no even foundation. Next 50 years. Very good.